be a righteous situation. It can threaten the security, public tranquility, public peace. Then restriction can be imposed by the state that you should not be moving around in this particular area, or you should not indulge in such kind of a practice, or for certain period of time you cannot go on even for the purpose of trade and commerce into this particular area or this particular jurisdiction. So freedom is available, but reasonable restriction on freedom can be imposed within the framework of Article 19, Subclause 1 to the Constitution. The question of reasonable restrictions does not mean that your freedom has been withdrawn or you are prohibited from exercise of your freedom. It is a temporary measure in order to ensure that in enjoyment of your freedom, you do not encroach upon the enjoyment of the freedom of another person. If you have a right, you also have a duty to ensure that the rights of the other persons are also safe and sound. They are also protected. They are also entitled to enjoyment of their rights, and your enjoyment of freedom or enjoyment of your right does not amount to violation of the enjoyment of the right of another person. Now, along with the fundamental right, that is freedom of movement, we also have the freedom and protection, that is Article 21, right to life and personal liberty. Now, Article 21, right to life and personal liberty, very clearly emphasize that no one can be deprived of his life and personal liberty except according to the procedure established by law. Along with it, Article 21, if you see, the language is very well worded, and it is the, I think, the most widely interpreted provision under the framework of the Constitution. Protection of life and personal liberty. How do we interpret this section in such a broad manner that we can bring anything to everything, which is in directly, indirectly, impliedly, explicitly affecting the enjoyment of the right of the person, his right to life, his right to personal liberty. That can be brought within the framework. And if we analyze the history of the constitutional framework, and right from 1950 up to 2020, we have evolved innumerable interpretations with respect to Article 21 as to how it can be interpreted as ensuring protection of life and personal liberty to the population. So if I look at, or if I date back from Menaka Gandhi, that was the authority which first brought into focus directly the concept of right to personal liberty, emphasizing that whether right to life, that is, a person can be deprived of personal liberty, and there it is amounting to infringement of his fundamental right under Article 21 to the Constitution, or Article 19 takes into consideration the freedoms and reasonable restrictions can be imposed upon the freedoms. So whether a personal liberty of the individual can be deprived of in the name of restriction or reasonable restrictions under Article 19 of the Constitution. So we have to analyze whether it is a deliberate attempt, whether it is likely to lead to wrongful consequences, whether it would amount to depriving a person of his right to enjoyment of his life and personal liberty. So, looking and analyzing the case of Maneka Gandhi, the interpretation under Article 21 to the Constitution very clearly focused and brought into the project the idea that personal liberty under Article 21 has been interpreted very liberally by the Honorable Supreme Court time and again. So, if I look at the case of Khadak Singh versus the state of UP, this is the judgment of 1963. So, the Honorable Court, while interpreting personal liberty, came down to the conclusion that narrow interpretation of personal liberty is not possible. It is not even permissible. Personal liberty has to be interpreted keeping in view the variety of rights which are available and which go on to make up the concept of personal liberty of an individual. And there are number of clauses which can be appreciated, that is the guaranteed freedoms under article 19 subclause 1 come within the purview of article 21. So we need to interpret article 21 liberally in order to ensure the enforcement and implementation of article 19 subclause 1 to the constitution. So again, if we analyze how to determine this, whose liberty, what is to be categorized as personal liberty and protection of personal liberty. So there have been a laid down a triple test to determine that personal liberty must satisfy these three essential ingredients to be considered as defining the concept of personal liberty. So, first is that there has to be a prescribed procedure to deprive a person of his right to enjoyment of personal liberty. Secondly, the procedure will withstand the test of one or more of the fundamental rights which have been conferred under Article 19 to the Constitution. And thirdly, it must also be liable to be tested on the scale of right to equality enshrined under Article 14 to the Constitution. So, if we analyze these things, Article 21 emphasizes on innumerable rights. If we analyze right, I have a right to seek the advice of the consul if I am arrested, right to be informed of the grounds and reasons of arrest, right of the person not to be subjected to bonded labor, right to livelihood. So these are the various interpretations which came out from the bench of the Supreme Courts over a period of time, defining the term personal liberty. And since you are entitled to the freedom, reasonable restrictions are there. But whether they are in conflict with Article 21 to the Constitution, or I have a liberty, I have the freedom, so I can exercise it when and wherever I feel the need and necessity. Then, right to immediate medical relief is also available, medical aid is available. So, when I have a right to fresh air, I have a right to live in a healthy environment, I have a right to clean drinking water. I have a right to live in a pollution free environment. So, right to freedom from noise pollution. So many rights. How we are interpreting them, that is under Article 21, right to life and personal liberty. So, everywhere this is coming into question, we are moving around and interpreting right to life and personal liberty, that it should not be encroached, it should not be violated. So the Honorable Court has been interpreting the concept through innumerable interpretations and has evolved multiple meanings to come out to the conclusion that right to liberty, right to life, and personal liberty has to be protected, and it is the due responsibility of the state to ensure the protection of these rights over a period of time, and individuals should not be restrained from enjoyment of his right to life and personal liberty. Article 21, if we look at the judgment of 2017 relating to another concept which evolved under the concept of right to life and personal liberty, that is right to privacy. So the right to privacy concept emerged before the Honorable Court uh, with the coming up of the concept of Aadhaar card, and we have a number of judgments which have been coming from the bench of the Supreme Court on the concept of right to privacy, and the right emphasized on protection of people's data, since it is an integral part and of the personal information which is enclosed in the data, and what personal security would be threatened Is it equivalent to violation of an individual's enjoyment of his right to life and personal liberty if entire personal information comes in the domain of the public at large? So whether both the state and the non-state actors are responsible, who should be cast with the responsibility. So we have a very landmark judgment which came from the bench of the Supreme Court, that is JKS Puttaswamy versus the Union of India. That is again a judge bench decision, and it focused on the idea of what is privacy, what is the concern of privacy, how technology can threaten and endanger both the state as well as the non-state actors, and how the claim of violations of privacy can be both against the state as well as the non-state actors. Now, here, while analyzing this case, the Honorable Supreme Court clearly emphasized that any information which is related to the private aspect of the person, they are being disclosed, and it is not an absolute right. An individual has a right. It is my right. I want to give the information, I will give. I don't want to give the information, I will not give. Even Article 20 gives me a protection. If I want to give the information, I will give. If I don't want to give the information, I will not give. I have a right to restrain. I have a right to silence. I have a right to save myself from self-incrimination. So rights are available to us. So here also the court said that the individual exercises his right. He has a control over his data. Any act which may lead, or any disclosure which may lead to violation of his privacy to a considerable extent must be prevented. The court also emphasized that Article 21 is expanding, it is enlarging, it is multiplying day by day. It is primarily because of the innumerable rights of the individuals which can be interpreted within the domain of right to life and personal liberty. So, right to privacy undoubtedly falls within the domain of Article 21 to the Constitution, and it is an inherent as well as an integral part of the concept of fundamental rights under Part 3rd of the Constitution. So, right to privacy is to be constituted as a guaranteed fundamental right of the people within the domain of Article 21 to the Constitution. Any conflict which may arise between the protection or right to privacy of the individual interest, any legitimate claim of the individual, the government must take due efforts and measures to evolve and implement its policies, frame necessary measures so that a balance can be maintained between protecting the interest of the individual and the responsibility of the state to ensure that if it is using the personal data of the individuals for its purposes, then it also has to ensure that it does not amount to threatening the right to privacy of the individual. So, the Honorable Supreme Court, while delivering the judgment through the 9 judge bench, very clearly stated that right to privacy is a right, but it is not an absolute right, and any intrusion on the privacy of the individual by the state or the non-state actors, it must satisfy the primary and basic objective that why state is doing so, it is because it is legally authorized and permissible to act in such a manner. It is supposed to ensure that the aim is fulfilled, the proportionality is duly addressed and answered. Analyzing the concept of privacy, if we also evaluate a little prior to this decision of in Puttuswamy's case, we also analyzed that 2018 saw two major landmark judgments which were delivered by the Honorable Court. One was related to decriminalization of um, homosexuality. That is in the case of Navtej Singh Johar versus the Union of India. Now, in Navtej Singh Johar versus the Union of India, we said 377 of the IPC was struck off. It is violative of the fundamental rights of the LGBT community. So, again, the idea is equality. Discrimination has to be done away with, and right to life and personal liberty is also available to this third gender. They cannot be deprived of this right because the constitution is addressing everybody. It says we the people of India. We does not mean addressing the male gender or the female gender. It is everybody who is a part of the society. So society is comprising of the male gender, the female gender, as well as the third gender or the transgenders. So that means fundamental rights are also accessible to this third gender. Therefore, Article 21, Article 14, Article 15 is to be applicable and redressable to this community also. So decriminalization of homosexuality was done, and the effort was to ensure and effectively implement the concept of equality under Article 14, 15, and 21 to this community. They can express their sexual identity. They also have a right to privacy. They also have a right that there should be non interference in the conduct of their personal affairs, and they have a right to be recognized, to be identified as the citizens of the country, as full members of the society, and they are entitled to enjoy all the fundamental rights granted within the framework of the Constitution. So they have to be treated within the definition of the term we the people of India. They are the people, they are the population. So fundamental rights are redressable to them also. So they are also within the framework of the concept of fundamental rights. Then again in Joseph Shine versus the Union of India, delivered in 2019, the Supreme Court once again emphasized on decriminalization of the offense of adultery, and it emphasized that Article 14, 15, and 21 of the Constitution uh, should not be violated, and the concept of adultery violates it under 497. So the in Joseph Shine versus the Union of India, it was a five-judge bench judgment. The court clearly emphasized that this disputed provision is being declared unconstitutional. There is a need to bring about an amendment in this provision. They do not emphasize for ending 497 because the problem is that adultery is existing in the society. So we cannot deny the fact that it is not there. It is very much present, but by merely declaring the striking down the provision and ending it is not a solution, but an amendment should be made to this provision so that the right under 14, 15, and 21 they are not violated. If we analyze another version of Article 21, right to life and personal liberty, there was a landmark judgment delivered from the bench of the Supreme Court, that is the popularly known as Ram Leela Maidan incident. And here the court evaluated the concept of right to life and personal liberty by interpreting the terminology sleep. Now, whether right to sleep can be considered as an integral part of enjoyment of right to life and personal liberty within the meaning of Article 21 to the Constitution. This came up for interpretation before the Honorable Supreme Court. Now, here the court once again re emphasized and analyzed that when the concern is of the individual, life of the individual, well being of the individual, health of the individual, we are providing them with all the basic benefits for enjoyment of healthy life. then sleep no doubt constitutes an integral portion. If you sleep soundly, you have a sound health. You are capacitated to work. You are healthy. So, sleep, right to sleep, was identified and recognized as an integral part of enjoyment of right to life and personal liberty under Article 21 of the Constitution. The Honorable Court very clearly laid down that if a person is deprived of his sleep, the effect is an, a torturous treatment given to that person, which is violation of right to life under Article 21 to the Constitution. The Supreme Court also emphasized that if any action is taken by the investigative agency on a sleeping individual or a group of individuals or people sleeping, then it is amounting to violation of their right to sleep, and it amounts to violation of right to life under Article 21 to the Constitution. And 21 is the basic fundamental right of the individual, which need not to be violated at any point of time. So, in order to ensure that the life of the population is not put in peril, effort must be made to ensure that right enjoyment of right to life, and it is coming through right to sleep is also permissible within the interpretation of Article 21. So, thinking and imagining of this even by the framers of the constitution may have been unimaginable, because they might not even have thought of or contemplated that at one point of time right to sleep would also be integrated as an integral part of enjoyment of right to life and personal liberty under 21, and the court may come out with an interpretation of this nature. So, with the change in time, with the change in circumstances, with the change in the growth of the society, as we have grown more, become more globalized, there have been so many transformations which have taken place within the fold of law, that we are evolving so many interpretations of this terminology that we ourselves were not sure that this could have been evolved as one of the interpretations under the meaning of right to life and personal liberty. Once again, I would analyze this one another landmark judgment which have been delivered by the court, that is the Triple Talaq case or the Sharabano's judgment. Here again, the question was on the constitutional validity and the treatment of equality under Article 14, 15, and 21 to the Muslim community or women belonging to the Muslim community who were subjected to unethical practices which were going on under the Muslim personal law in the name of triple talaq, in the name of polygamy, nikah halala, and they were challenged as violative of Article 14, 15, and 21 to the Constitution. So here, once again, the Honorable Supreme Court has set aside the concept or the practice of talaq bidat, that is triple talaq at a single pronouncement, allowing a Muslim man to divorce his wife instantly and irrevocably. So this is outright violation of the concept of equality, equal treatment, equal protection, and violation of right to life and personal liberty of the individual. So gender discrimination is not permissible. Gender justice has to be provided, irrespective of the fact that she is a woman and that she is belonging to a Muslim community. India does not advocate for classification on the basis of religion. So, we are having a secular basis, and since the criminal code of the country, the civil code of the country does not classify on the basis of religion, we are the Honorable Supreme Court emphasized that such classification is not permissible. It outrightly amounts to violation of the concept of gender equality under Article 14 to the Constitution, which is to be protected. Therefore, for promotion, advancement of the rights of women, for providing gender equality to the women belonging to the Muslim community, protection has to be provided and ensured to them, equal treatment has to be given to them, and they are within the purview of the concept of fundamental rights under Article 14, 15, and 16, and 21 to the Constitution. So the Honorable Court reiterated the fact that when we talk about fundamental rights, we are not only concerned with one aspect, but we are transgressing into every area where violation or there is ignorance or discrimination is being practiced. Then, with respect to Article 23 and 24, right against exploitation, the court very clearly emphasized that Article 23 and 24 of the Fundamental Rights imposes a clear prohibition on trafficking in human beings and on forced labor. It states that any form of forced labor is prohibited and any violation of the provision is a punishable offense in accordance with the law. It also emphasizes that it is the duty cast upon the state that it will restrain itself from imposing any compulsory service for the purpose of or for carrying on any kind of discrimination on the ground of religion, color, caste, creed. So, immoral trafficking is clearly a prohibition. Child labor is clearly prohibited. You are not entitled to indulge into any such kind of practice. State has been tasked with the responsibility to ensure that the persons belonging to the socio-economically depressed or weaker segments of the society are not subjected to exploitation. Rather, they also have a right to life, and their right to equality and right to life has to be protected. Right to work has also to be ensured to this part of the population so that they are not leading a life of helplessness, despair, forced to indulge into begging or to do acts or indulge in activities which are below their concept of respect and dignity. So every time the court feels that the fundamental right of the person is threatened, it will initiate necessary measures to ensure that the right is protected at all points of time. So the court is focusing repeatedly on ensuring that any kind of exploitation which is existing in the society, the judiciary has been taking the initiative of providing protection and ensuring that right to life and right to equality is protected under all circumstances at all points of time, so that children who are forced to work under such conditions and circumstances in factories, in industries, or in other forms of labor, they are also entitled to protection. They are provided alternatives, and no child below the age of 14 can be employed in any hazardous industries. Any person indulging into such kind of practice can be subjected to a punishment within the provision of the law. Then fundamental rights also provide freedom, that is, religious freedom is also available within the fold of Article 25 to 28 of the Constitution, which emphasizes that every person has a right to profess, practice, and propagate a religion of his or her choice. And once there is no restriction, there is no bar, no one can force you. It is your choice. Whatever you feel like, you are authorized, entitled, having the absolute liberty to profess and practice the religion of your choice. You can even preach, you can even propagate the religion of your choice. So the judiciary has been ensuring that equality, even in the matter of religion, is available to all individuals, to all groups, irrespective of the faith the person is believing in. The Supreme Court, in the case of Ismail Faruqi versus the Union of India, re-emphasized on the fact that right to equality is deeply embedded within the framework of the society, within the framework of the constitutional pattern of fundamental rights, and they have to be protected, they have to be ensured, and judiciary has been vested with the due responsibility to ensure that the rights are protected. It has always tried to evolve a very harmonious construction, a very beneficial construction whenever the issue has been of religion, particularly if it has been related to the concept of the minority religions which are being practiced by the population, so that protection is accessible to their religion, to their cultures, to their social, to their educational rights, which are available under the law of the land. Article 21A, that is, guarantees the protection of right to education to the population, which has now been made an independent right, that is right to education under 21A to the Constitution, which is again has been added within the framework of the Constitution. Then 29 to 30 relates to the cultural rights, that they are also protected. Minorities can establish and administer their own educational institution, and they are already being managed, and they are entitled to ensure that Article 14 and 19 at no point of time are being violated, but redressal, in case there is a violation, then redressal is available to the population, so that equal treatment within the fold of the Constitution is available and accessible to the entire population. So, if we analyze in brief, or one in a concluding statement, I can say that fundamental rights are the basic rights which are available to the population, and they are being protected by the judiciary time and again whenever there is a threat, whenever there is an encroachment, whenever there is a fear that violation is done even by the state. So judiciary has been spearheading the cause. It has been contributing to ensure the protection of the fundamental rights, and the Constitution has been functioning fundamentally, protecting the rights of the population up to this point of time. And we have a very high hope that with the judiciary discharging the responsibilities, the rights of the population will be secured within the framework of the Constitution. Thank you, everybody.
Thank you, ma'am. Now I would seek permission to bring up the questions from the viewers, if you don't mind.
Yeah, yeah, most welcome.
Ma'am, the first question is, as you know,
Yeah,
Dr. B.R. Ambedkar once said that the day the Constitution is wrongly used, I will be the first
right,
person to shred it and burn it.
right,
But but the fundamental rights were compromised. I'm talking about the 1975 national emergency.
right, right, right.
Do you think that the Constitution is watertight to prevent any such situation in the future?
Definitely. See, no doubt at the time of the emergency, constitution rights were violated. But that was, I think, a very temporary phase since the government was in absolute control at that point of time. But if you see the point after the emergency, again, the constitution has been re strengthened and reinformed. We made the necessary amendments. Whatever things were added or embedded temporarily by the government at that point of time were done away immediately after the emergency period was over. So constitution is having a very strong embedded thread work. We cannot say that the constitution is gone just because one incident happened. No doubt it was a threat at that point of time, but the constitution, the way it has been written, the way it has been formatted, it is not easy to violate and break it. Changes are there, transformations are there, because every person comes with a different bent of mind. But aided with the executive, aided with the judiciary, we are having a very, very powerful framework which is still there and very much functional to redress the rights of the population. So we do not foresee that a situation like this may come up once again, because today we have changed number of things, we have re-embedded things, and we have invested the constitution with much more strength. The judiciary today is more independent than it was in 1975. So today we are not only talking about the independence of the judiciary, we are also emphasizing on striking a very, very strong balance between the executive, legislature, and the judiciary. If you analyze in the current time period, judiciary restrains itself from sitting down in the matter of policy making. It is giving a guideline, it is giving a direction, it is evolving a law for a temporary period of time till the legislature has not evolved the law. But judiciary is not sitting down to say that I am taking the seat of the legislature, I will make the law and also I will also declare the law and I'll also enforce the law. So judiciary itself has put restraints so that it does not encroach into the jurisdiction of the other two areas. A balance is being maintained. So it is ensuring the independence of the executive, the legislature, as well as ensuring the independence of the judiciary itself. Right? Yeah.
And the second question is, as you said, that the judiciary is working hard on providing the fundamental rights.
Yeah.
But looking at the situation of cases in Indian courts, the situation
Right.
is not very much appreciable. So, can it be said that there is a right to speedy remedy by the judiciary in the interpretation of Article 14 and 15? And if it is there, do you think it is rightly enforced?
Definitely. See, the question is that there is no doubt a delay which is taking place in the deliverance of the justice to the population. But it is not always because of the delay created by the judiciary. So there can be dates which are being given at a longer period of time, but it is because the body itself is deficit. The number of judges occupying the chair is very, very less. We have multiplicity of cases, litigation, which is coming up every day. But what about, are we equipping the judiciary with those the number of judges? We are not providing the machinery. For every say 135 cases, there is one judge. So if this is the statistics for every place, humanly it is impossible for a judge to address 135 cases in a day. Dates only may be possible, but if you say you have to listen to a case, you have to listen to the arguments, you have to appreciate the evidence, you have to take the cross examination of 135 cases, humanly it becomes impossible. How will you do it? You cannot be paying a lip service to the system of justice. You have to give a very, very patient hearing to come down to a conclusion, to analyze and decide whether the person is guilty or he is innocent. So everything, even if you take out the matter of civil law, cases are pending for the last 60 years, 70 years. Your father, the judge's father was the judge and he was the, say, trial judge at that point of time. Today, the son has taken the chair. The father has retired long time back. So, son is coming, he is taking the chair, he is picking up the file of his father. So, how do we expect the system to be delivering? Delay undoubtedly is a part of the system, but still, if justice is available to us, we say there is delay of justice as good as denial of justice. But there is this flaw within the functional of the system. We do not say judiciary does not want to give justice because that is a teamwork. Number of people, number of implications, number of rules are evolved, which are resulting in this reason for delay. So one solution which I believe is that there should be increase in the number of judges, and there must be a strict observance of deliverance on their part. Deliverance should not be a showcase. Just because I want a batch, just because I want that I have to complete this many cases in this month, so I will get one number. That should not be the idea. Idea should be that I have to deliver because I am under a binding responsibility to ensure deliverance and justice to the person who is approaching you. Because one thing is a hard fact that ultimately what may come and what may go, people still continue to have faith in this institution of judiciary. People are not going for one to one. People are not going for personal vengeances. They still believe that ultimately, even if the lower court has not given me justice, the high court will give. If it does not give, ultimately the Supreme Court will 101% deliver me justice. Redressal will be given to. So this hope in the population is still alive, and we believe that this is the functional stone because of which the constitutional framework is surviving. So long we have faith in the system, we will be able to improve upon the system, and people will continue to work hard to ensure that the rights are protected. And judiciary continues to exercise this. That is the reason why we are evolving so many interpretations. Otherwise, nobody could have imagined the right to liberty can come up to right to privacy also, because this is the emergence of a new ideology with the coming of digitalization. Everyone can enter into everywhere. So, looking at the way the world is transforming, judiciary is trying to update itself. We are updating the laws every day. So, hopefully, we will be able to cover up this flaw and try to ensure that this concept of delay and denial of justice does not continue endlessly, but we are able to improve upon the system and provide a better deliverance to the population.
Ma'am, we have a similar question. The third question
Right,
is, they say the fundamental rights are only for the riches and not for the poors. Would you
right.
like to comment on this?
Okay, partially it is can be said to be true because the population will use the situation from that perspective. When you look at the courts, we believe that it is the rich man's domain, the amount of money that is involved. But when you look at the cases where even poor people have been provided. People's Union for Civil Liberties have been making initiatives. Number of NGOs have been working hard to come out with the redressal for the aggrieved. If you look at the case of Vishakha versus State of Rajasthan, it is an NGO which has been spearheading the movement, resulting in bringing in the sexual harassment against women at workplace. So we have the act which is now intact. Similarly, we have POXO, which has been evolved. So it is not the initiative of the rich man. It is the initiative of the society comprising of every class of the population, which is contributing to bringing about this change. So I do not agree on this aspect that it is only the rich man's domain, though superficially it does appear to be a rich man's domain. It is not factually the truth, because it is the actually the ground reality when we analyze that how many rich people are going to the court of law. Only the companies are moving around. Other people, they do not go. They have their they have a solution to the things. They prefer to go for mediation and arbitration and conciliation. They do not go for open litigation. They consider it as a wastage of time and money. They do not waste their hard earned money over there. So it is the poor man who does not have other alternatives for redressal, who still has faith in the judicial system, who has been caught wrongly within the framework of the system. So just to say that it is a rich man's domain, it is not right. Yeah.
That's all for the questions, ma'am.
All
Thank
right.
you for this special lecture. I would like to thank you on behalf of the student organization Democrats. And now I would request Dr. Meenu Chopra to bring up a vote of thanks.
Just a second. Hello. Good evening, ma'am.
Good evening.
So, ma'am, it has been a pleasure to see you along with our students itself. So, it
Thank
had
you.
been a good lecture as such. I think, like the academically, the students might be benefited from the inputs given by yourself, ma'am. Thank you so much, ma'am, for sparing your time for our students. Thank you so much, ma'am.
Thank you. Thank you. You're most welcome.
Thank you, ma'am.
Thank you, ma'am. Thank you, everyone, for
Thank
watching. This session was organized by Student Organization Democrats under the Division of Student Affairs, Lovely Professional University. Thank you.
Thank you.